Companies Act, Section 441, Compounding of Certain Offences. Section 441 of the Companies Act, 2013 provides a mechanism to compound, i.e., settle or resolve, specific offences under the Act without undergoing a prolonged criminal trial. Compounding allows companies and their officers to rectify defaults and pay a prescribed monetary sum instead of facing prosecution. The provision promotes compliance, reduces litigation, and helps relieve the burden on courts and special courts. However, compounding is permitted only under strict legal limits and not for all types of offences. 1. Offences eligible for compounding. Any offence under the Act that is punishable with fine only, or punishable with fine and imprisonment, but not imprisonment alone, may be compounded, whether committed by a company or any officer of the company. Compounding may be done before prosecution is filed, or even after prosecution has begun. This gives flexibility to rectify mistakes early and avoid criminal proceedings when possible. 2. Authority to compound offences. Compounding may be done by a. the tribunal, NCLT, for offences involving larger penalties. b. regional director, RD, or other authorized central government officers where the maximum fine does not exceed 25 lakh rupees. The authority will prescribe a monetary sum to be paid to the central government as part of compounding. Conditions include: the monetary amount specified cannot exceed the maximum fine under the relevant offence. Any additional filing fee already paid under Section 403(2) will be taken into account. Restriction: compounding is not allowed if an investigation has been initiated or is pending against the company. This keeps serious breaches under regulatory scrutiny. 3. Restriction on repeat offences. A company or officer cannot seek compounding if a similar offence was compounded in the previous 3 years. Explanation: if a similar offence is compounded after a gap of 3+ years, it will be treated as a first offence. This encourages companies to avoid repeated non-compliance and maintain good governance. 4. Procedure for compounding. a. An application for compounding must be filed before the registrar, who forwards it with comments to NCLT or the RD. b. Once compounded, the company must inform the registrar within 7 days. c. If compounding is done before prosecution, no prosecution will be launched against the offender by the registrar, any shareholder, or any authorized government representative. d. If compounding occurs after prosecution begins, the registrar informs the court. The court then discharges the accused company or its officers, ending the criminal case. Thus, compounding prevents or ends criminal litigation. 5. Filing compliance during compounding. While compounding defaults relating to non-filing of documents, NCLT or the RD may direct company officers to file the required documents, pay the regular fee and additional fee under Section 403 within the time specified in the order. This ensures compliance is corrected promptly. 6. Penalty for non-compliance with compounding orders. If an officer fails to comply with the above directions, the maximum fine will be twice the amount provided for the original offence. This acts as a deterrent against carelessness or intentional delay. 7. Offences not eligible for compounding. Offences that involve imprisonment only, or imprisonment and fine, are not compoundable under any circumstances. These are typically serious offences such as fraud, falsification of accounts, and public interest violations. 8. Exclusive procedure. The section concludes by stating that no offence may be compounded except as per the procedure and limitations laid out in Section 441. This ensures transparency, uniformity, and prevents misuse of compounding. For more details, contact us.